it's taking away the parents' ability to basically have their opinion.
Governmental intervention in the family.
Yeah, it's mom, dad, and government.
What is going on, everyone? It is Mark Reel Jr., the Fathers Rights Attorney, and you are listening to another episode of the Fathers Rights Playbook. And today we have Inland Empire Senior Trial Attorney Brian Mayer. How are we doing today, Brian?
Great. Glad to be here as always.
Awesome. So today we have pulled out some topics. One of those is discovery, how you can conduct discovery in domestic violence restraining order situations, which can be a challenge. So, Brian, I'll turn it over to you. First, let's go through with the listeners the timeline when you are served with a domestic violence restraining order.
So, first, do we want to explain what discovery is, or are we?
Yeah. Let's go. Okay. So, let's start. That's a good starting point. Let's go there. What is discovery?
Discovery is just the general term that we use in law to describe the process of your right to collect information about your case and that is relevant to your case. Now, that can be in the form of asking people questions. It can be in the form of acquiring documents. That can be bank records. Pretty much anything that you can think of. That's what we talk about when we mean discovery.
Okay, so it's gathering information about your case. We have deposition, which is asking the other party questions, live testimony. We have different forms of written and production-based discovery where we can find this information. So what is the challenge in restraining order? So we'll go over the timeline first, because that's really, I guess, hurdle number one in discovery.
Right. And this is where it really is important to have counsel with you that knows what they're doing and how to approach your case, because it starts to get very legalistic very quickly. In California, restraining orders have to go to trial within 21 days, or in certain rare exceptions, within 25 days. But either way, it's an extremely short timeline in the context of how these things normally go.
Or as little as 5 days from when you're served.
That is absolutely true. So the protected party will file their document. They have to be given a court date within 21 days of filing, and they have to serve the other party as late as 5 days before the trial, and even then they can get exceptions to allow for fewer days. So for the typical restrained party, they can have just a matter of a few days between when they even know a restraining order has been filed and when they have to go to court to defend themselves at trial. By contrast, if you're in any sort of civil case, if you're in a criminal case, these things will go on for months, if not years at times. So it's this process that is designed to get to the right answer and not the quick answer, except when it comes to restraining orders, in which case, in the situation of restraining orders, it's as though the goal is to get to the quick conclusion and not necessarily the right one. It creates a profound disadvantage for the restrained party in that regard, especially if they don't know this is coming, which oftentimes they don't.
And part of it is, the foundation of it is that they are infringing on fundamental rights of the restrained party, and so it's supposed to be protecting their rights or only limiting their rights for a period of time, but it ends up being a huge disadvantage in a lot of cases.
Absolutely. And to understand, first, what happens is typically when the person goes and files for a restraining order, they're oftentimes granted a temporary restraining order. Now, they usually don't have to prove anything at all in order to get these temporary restraining orders. They only need to make allegations that, if proven to be true, would be a sufficient basis for a restraining order.
Let's talk about how low that bar is.
Let's talk about that. So,
an attorney, have you ever said, very few attorneys get this wrong. If you file a restraining order, you usually get a temporary.
That's absolutely true. And what we have is there are different standards of evidence. Now, when everyone knows most everyone knows in a criminal matter, you have to prove guilt beyond a reasonable doubt. And there are some cases where you have to prove guilt or liability by a clear and convincing evidence. In civil matters, generally, you have to prove by a preponderance of the evidence, meaning it's more likely than not. But to get a temporary restraining order, you have to, and I'm going to use a $50 Latin phrase here, to get a temporary restraining order, you only have to present what's called a prima facie showing of evidence. And that's what we're talking about. It's making an allegation that, if proven to be true, would be a basis for a restraining order.
If everything you write on the forms is proven true, they would grant a restraining order.
Or if enough of what you write is proven to be true, it'd be granted for a restraining order.
Yeah.
So if I go to court and I say, if we had a domestic violence restraining order, if you were my brother, we lived under the same roof, so we qualified, and I said, Mark Reel threatened to murder me, he's my brother, I have a temporary restraining order on you now. And along with that temporary restraining order come immediate and unadjudicated issues that affect your freedom. You cannot possess or hold on to any firearm or ammunition. Oftentimes, you can't come within 100 feet of your place of residence. You can't come within 100 yards of me. You can't talk to me. If any of these things happen...
You can't have anybody else talk to you for me.
Correct. And if any of those things happen, by law, the police have to make an arrest if there's merely probable cause to believe that you violated that restraining order. So I show them a text and I say, hey, this came from my brother's phone. He just said, hi, how are you doing? He's been served from this restraining order. Guess what? You're getting arrested.
Yeah. So let's tie this back in. So you get served with a restraining order. The timeline is already crunched. And presumably, and I won't put a percentage or anything out there, but a good deal, I would say, of requests for a restraining order. There may be like a core allegation that's very serious, but a lot of times then it's just throw everything against the wall and see what could maybe stick. So presumably the other party's got some evidence, some text messages, some documents. Maybe they've said some contradictory things, and we need to get that information from them. And that comes in, we talked about prior to the show, the Civil Discovery Act. And in this year, they've made some changes. They made some modifications to it that, I guess, in our opinion, we kind of harms the party that is restrained. So can you go over what the Civil Discovery Act is and what it allows them to do?
Yeah, so to understand the changes, to understand what the law is now, we first have to look at what things were prior to January 1st of 2024. Now, you mentioned it. There's something in California, it's called the Civil Discovery Act. Okay, and again, remember, discovery is that process of being able to collect information for your case. It's the right to demand and collect information for your case. So under the Civil Discovery Act, the opportunity to collect discovery ends 30 days before the first date of trial.
Wait. But a restraining order trial is within 25 days.
Exactly. So you have, right off the bat, you have no opportunity under the law to compel any sort of information that might help defend you in these allegations against you, because the timeline has already run out before your case even starts. Now, this is a problem, needless to say, if you're trying to defend yourself. And the legislature, I will give them credit, they tried to address this, and this comes from a legislature that loves to make domestic violence restraining orders easy as can be. The legislature tried to address this, and they partially succeed, but they mostly failed. Now,
We are in California.
here's what the law changed. We are. Okay. Nobody has restraining orders like California. I'll tell you that. So here's what the law does. Okay. What the law, at least in principle, it's in its Family Code section 6309. Okay. What the law does, the basis of it is that it allows for individuals to ask the court for time to conduct discovery and to order that the discovery is allowed. Now, the good news, and this is what they got right, is now it is a possibility. Okay, but the bad news is how this is the bad news is how this is going to be implemented. What it's going to actually look like.
Okay, and what is that?
So the first problem is that the way the statute reads is that it is at the discretion of the judge as to whether or not the discovery should take place. Now, we hope the judges do a good job. Okay? We hope they do. Sometimes they do a good job.
Many good judges out there.
But oftentimes you have judges out there who don't know what they're doing, or they come into these situations with their biases, and everyone at this firm, for example, is very aware of gender biases when it comes to all of the family law dynamics, including, and I would say most especially, pertaining to restraining orders.
Yeah.
And in fact, I'll say this, to the extent that it's not just how quickly the court will grant restraining orders against men who are, when violence is alleged by women, but there's also disparity in terms of the duration, the severity of the restraining order when it's granted. A man who slaps a woman in the face will get a restraining order for 3 years. And if you switch to the parties, a woman slaps a man in the face, it's going to be 1 year. And that's not the rule, but we see it.
I think the most dramatic and most damning is, I call them mean text restraining orders.
Okay, yeah.
I don't know how many. I don't think I've ever seen or been in court when a woman has had one of these granted against her, but candidly, I would say probably 75 to 80% of restraining orders over the last 2 to 3 years of the firm that haven't gone our way haven't been because he hit her or he did something physical. It's because he said something mean.
And this is why California is so special when it comes to restraining orders, is that you and I both know, and we deal with these every single day. I don't know how many I deal with in the course of a year. It's amazing how many of these restraining orders involve actual physical violence or allegations of violence.
I would say single-digit percentage. I bet you if we did the math.
I'd be curious to say that my gut tells me less than 10%. It's not. It's like you said. It's mean words or the wrong mean words.
Or the 2020 update where we included coercive control, which no one can really fully define, but it's domestic violence.
Well, and that's exact. Well, hey, I don't feel like I don't like your family. They can't come to the house.
Yeah.
Well, sorry. Now you have a restraining order on you, and you lose your kids.
Yeah.
So it's easier. It's about as easy as sneezing in California in terms of getting a restraining order. And now I've completely gone off topic. I don't remember.
Yeah, let's pull back. So we have obviously the time constraints. Now the positive it gives you a direct path to go to the judge and ask for discovery. Now, what are the downsides?
Right. So,
because they can go to the judge as well.
Absolutely. So again, going back, I give credit to the legislature for at least trying to make this terrible situation a little bit more fair to the accused. And of course, the accused are usually men. And I think our next topic of discussion could easily be why we see how restraining orders look different and why they're different between men and women, how men regard violence versus women, and all that. So the positive side of all of this is that we do see that the legislature has made a sincere attempt to try to work out this problem that's created by the expedited restraining order process. But it has some very serious limitations, and frankly, the kinks are not even close to worked out. In fact, in some regards, things are looking a little bit worse now that this is in place. So, first of all, as we said, it's at the court's discretion whether or not to allow for any discovery to take place. But I'm not so worried about that so much as I'm worried about a few other things. Number one of the factors that the court must consider when deciding whether to allow time for this discovery to take place is the emotional impact that it will have on the parties or any other parties involved. And to translate this, what this means is if I wanted to sit the accuser down as the attorney and ask them questions about the domestic violence, the domestic violence claims, they could say, oh, this is going to be so emotionally difficult for me. I can't do this.
This is going to hurt my feelings.
It's going to hurt my feelings. I can't handle the stress. He victimized me by being mean to me, and now he's victimizing me again by making me answer questions about this court action I've initiated. And the court can say, no, you can't talk to her, or you can ask her the questions, but they have to be written down, and she has to have time to write. She can give you the written answers. And by the way, I'm going to set the timetable for when all this has to take place. And you know what? We can start the trial now, and we'll just hold on to that, and we'll come back in 6 months from now while you've been under this temporary restraining order the entire time. So it definitely is structured in a way that allows the court to protect the accuser.
And there were air quotes there for those listening to us.
That's okay. Thank you. There were air quotes there to protect, air quotes, the victim, the alleged victim, the accuser, from the emotional hostility of this restraining order process, which obviously, if you're dealing with someone who is exploiting the process to begin with to get leverage in their case, then they're not going to have any qualms about exploiting this discovery process.
You know what I've always wanted to do?
What's that?
And I think this would be like an inception moment for judges. So if we'll just say a female is withholding children from the father, making threats, making demands, and then she goes and files a restraining order that doesn't allege anything physical, he's emotionally abusive, this and that, to turn around and file a competing restraining order saying that her behavior is more extreme, and force a judge to say that, force a judge to make a decision on basically, is withholding the kids and making threats worse than whatever she's alleging.
If we saw more action from the bench, if we saw less tolerance for the exploitation, I think that we would see a change in the culture, because the word is absolutely out there that you can make these claims and use it to get leverage.
It's the only thing the court will help you file these documents. It's the only documents that the court will ensure that you do it right.
That's right. And they will make every accommodation to make sure that your paperwork gets through. It doesn't matter how flimsy it is, how poorly worded it is. If you say the word domestic violence is the magic word.
Go to the third floor, there's a window, they'll call you when they're ready to help you.
That's right. And so part of it is and so what we do see this, and this is just a reality in family law, and this is why, I tell people when they come to us, when a restraining order has first been filed, or if they come to us, sometimes they sense it's coming and they come to us. That is when we are most able to help them. That's when we can have the most effect, because whatever happens with that restraining order is going to affect the entire rest of their case. Most especially if they have children, but it can affect other things. It can affect their jobs. Okay, because number one, if you have to have any sort of contact with firearms, well, good luck. Yeah. All right, and there are things that can sometimes be done about that, but you're at least, at a minimum, you are facing the possibility of losing your career. If you need any sort of security clearance for your
credentials
job,
or clearances,
right? Kiss that goodbye. Okay,
contractors, contractors' licenses could be on the line.
Absolutely. But even if you don't have it, affects your your custodial rights. But even if you don't have children, even if none of those things are true, it can affect spousal support. It just reverberates throughout the entire case, and that's oftentimes why we see it at the beginning of the case, because that person has consulted an attorney and they said, "Hey, if you really want to get a leg up in this, you can do that." I can tell you, I'm not going to name a name, but there's an attorney in town here who I'm telling you, if you walk into that man's office, he will say, "Let's figure out a way to file for a domestic violence restraining order." And did you fight often? What did that look like? Okay, was there yelling? How loud did it get? Looking for something to find domestic violence to give leverage.
That's how broad the legislature's defined it.
That's right. There's no other state like it. So congratulations, California.
I tell everyone, if you've been in a relationship for more than a year in the state of California, there is no way you have not statutorily committed domestic violence.
Well, at least all I'll say is there's probably no way that you've done it that it couldn't at least be argued with a straight face.
Yeah.
And, that's part of the other one. I don't think we were planning to talk about this, but just, the perfect example of just how unreasonable and how asymmetric the approach is to in terms of how the parties are regarded in this. We saw legislative change last year. It went into effect January 1st, 2023, Family Code Section 6344 regarding attorney fees for these domestic violence cases. And what the statute says is that if you are the person requesting a restraining order and a restraining order is granted, then the court shall order the other side to pay your attorney fees. But if you are defending a restraining order and you prevail, then the court may order attorney fees if it finds, and I'm paraphrasing, if it finds that there was bad faith. So if you win, you win and they have to pay your fees. But if you are defending and you win,
if you get dragged into it with no choice,
if you get dragged into it, allegations are made against you and they don't prove their case. First of all, you first have to prove that they did it just because they were out to get you. And even then, the court is not required to order your fees.
She doesn't have any money. She relied on him. I don't know if I have. I mean, it's a rare case where there's attorney fees going the way of the individual who had to defend it.
It is a rare case. And, I will say this. It depends on the court and depends on the judges. I will say that the judges have gotten, collectively, we've seen a lot of improvement over the last 10 years.
We've seen a massive turnover over the last 24 months. There's very few judges in the Inland Empire who are on the bench that were on the bench 2 years ago. The bench has gotten much, much younger and much more progressive in their thought.
I mean, that's absolutely true. And I think there's several reasons for that. So that's created its own set of problems. It's solutions as well as anytime there's a change, there are good things and there are bad things about it. And I think, in this legislation is a perfect example, both good and bad.
Yeah. I think the biggest challenge with legislation in California, and I see some of this being active in equal and shared parenting, is the domestic violence groups in California have so much power in Sacramento. We see so many bad laws. Like this year, we probably had just about the craziest law almost pass. If our lovely governor wasn't preparing to run for president, probably would have it where it was around a child, didn't state an age, could just say they were the other gender, and if you didn't immediately affirm it, the kids were stripped away from you.
That's right.
Your 4-year-old could come home and say, I'm a boy now. And if you didn't agree with them and they told a mandatory reporter, DCFS would have to open a case.
And, there is just the news. This happened. There's a case in Indiana where that's exactly what happens.
Mm-hmm.
The parents did not affirm, and the state said, you lose your child. And, regardless of where you stand on that, it's taking away the parents' ability to basically have their opinion.
Governmental intervention in the family.
Yeah. It's mom, dad, and government, or mom, dad,
the third parent.
The third parent, the government, right? Yeah, Uncle Sam. I get. Well, state of California. So.
Yeah. All right. So we started to go down a rabbit hole there, but that was a lot of information. Thank you very much, Brian. To all our listeners and viewers, I hope you gained a lot of knowledge about restraining orders and more specifically discovery if you are served with a restraining order. And for all our viewers and listeners, we'll see you again next week with the Fathers Rights Playbook.